Hello friends, welcome to my YouTube channel again. So in today's video, we will going to see when an NGO's FCRA registration will be cancelled. So it is in light of the development that recently several NGOs registrations has been cancelled by central governments. So in today's video, we will understand why central government has from time to time has cancelled the registration of some NGOs and what are the features of this Foreign Contribution Regulation Act, and at last we will also see a prelims based question which can be framed from this topic. Before moving forward, I want to tell something about me. My name is Abhishek. You are watching Current Affairs series with me. So what happened recently? The Ministry of Home Affairs has cancelled the Foreign Contribution Regulation Act license of Rajiv Gandhi Foundation and Rajiv Gandhi Charitable Trust, organizations that are associated with Nehru Gandhi family for alleged violations of the provision of the act. So recently, Ministry of Home Affairs, who is the nodal ministry for Foreign Contribution Regulation Act, has cancelled the registration of these two NGOs. And so, in light of this cancellation of registration, Ministry has cited that these two NGOs have violated the FCRA Amendment Act 2020. Now, what are the law on foreign funds? FCRA seeks to regulate the acceptance and utilization of foreign contribution or foreign hospitality by certain individual or associations or companies and to prohibit such acceptance and utilization for any activities detrimental to national interest. Law was enacted during the emergency in 1976 amid apprehension that foreign powers were interfering in India by pumping in funds through independent organizations. An amended FCRA was enacted under the UPA government in 2010. A legal challenge to the 2020 amendments was rejected by Supreme Court in April this year. Basically, whole gist of this statement is that to regulate the contribution from foreign, the government has enacted FCRA Act 1976 during the time of emergency due to huge inflow from foreign funds. So government has decided to enact this law in the national interest to protect the sovereignty, unity, and integrity of India. But this act was amended in the year 2010 and certain provisions were improved. But again in 2020, this act was amended and more regulations, more protections were given to the NGOs. That is, more regulations or more over regulations has been increased. So this 2020 amendment was challenged in the Supreme Court, but Supreme Court has rejected the challenge and make 2022 amendments 100% true and valid. Now, what is the provision of the Act? So, broadly, the FCRA requires every person or NGO wishing to receive foreign donations to be registered under the Act, to open a bank account for the receipt of the foreign funds in State Bank of India, to be very precise, Delhi branch, because this was written in the amendment of 2020 that when an NGO try to receive a foreign fund, it must receives in only one bank account, that is State Bank of India. But after 2020 amendment, the bank State Bank of India must be of Delhi branch, none other than that. The act prohibits receipt of foreign fund by candidate for election, journalist or newspaper and media broadcast company, judge and government servants, members of legislature, political parties or their office bearers, and organization of a political nature. So act prohibits these persons to take any foreign contribution in their name. Now, how registration of this FCRA takes place? Basically, NGOs that want to receive foreign funds must apply online in a prescribed format with the required documentation. FCRA registrations are granted to individuals or associations that have definite cultural, economic, educational, religious, or social programs. MHA is required to approve or reject the application within 90 days, failing which it is expected to inform the NGO of the reasons for the same. Means Ministry of Home Affairs will approve the application within 90 days. If ministry fails to do so, then ministry has to provide a valid reason to the NGOs. Now, when an approval should be cancelled, so there were one important reason that if in the opinion of central government it is necessary in the public interest to cancel the certificate. Suppose an NGO is doing such a work which is against the sovereignty, integrity, and unity of country like India. So government, in the opinion, central government, in the opinion, may reject the application, may reject the approval in the public interest. Now, when an NGO's publication, when an NGO's registration is cancelled or approval is cancelled, NGO will not able to register up in 3 years. Means after 3 years the NGO again have to register, means they have to take a break of 3 years. Now all the decisions of this home ministry can be challenged in high court and consequently Supreme Court. So there is no final or authority in this act. Now let us see a UPSC prelims based question which can be framed from this topic. Consider the following statements. Foreign donations accounts can only be opened in State Bank of India. It is true statement. Foreign donations accounts can only be opened in State Bank of India. It mandates contribution from foreign funds only from FIIs. Means the FCRA Act mandates contribution from foreign funds only from foreign institutional investors. This is a false statement. It is nowhere written that only FIIs will contribute in foreign funds. Which of the following are correct? So A will be true, B is false. So our correct answer is A. So this is all from me regarding FCRA regulation. If you understood the topic, then subscribe my channel, and if you gained something from this topic, then don't forget to share this channel. Thank you.